Court reporter talking over one another. She can't take down two conversations at once, so I'll ask that you wait till I finish my question, and then you answer, and I'll similarly wait for you to finish responding, and then I'll ask a new question. Okay?
Okay.
All right. Similarly, because we have a court reporter, we need to try to avoid inaudible or unintelligible responses, such as a head shake, yes or no, or an uh-huh or a nuh-uh, because the court reporter can't take down head shakes and the others just don't read clearly in a transcript. Okay?
Okay.
All right. Today, during the deposition, your attorneys might be inserting objections to the form of my question. What they're doing is they're preserving those objections for trial or any other hearing in this matter. However, unless they instruct you not to answer, you are still required to answer my question. And if for some reason the objection caused you to forget the question, please speak up and let me know and I'll restate it. Okay?
Okay.
All right. Um, Along the same lines, if for some reason we cut out or you don't understand one of my questions, again, speak up, let me know. I'll be more than happy to rephrase the question or restate it so that you do understand it. Just note that if you respond to one of my questions, everybody here will believe that you understood it and answered accordingly. Okay?
Okay.
All right. Today, some of my questions might ask for you to provide an estimate. And what I don't want you to do is guess. But I am entitled to your best estimate based on your personal knowledge of events and times. Um, the classic example that attorneys give to differentiate between a guess and an estimate is if I were to ask you to estimate the length of the desk in front of me, you wouldn't be able to do so because you can't see it and you've never seen it. So any response would be a pure guess. But if I were to ask you to turn around and estimate the length of the door behind you, you've seen it before. You can turn around, look at it. Even if your answer wouldn't be tape measure accurate, you'd be able to give, say, approximately 7 to 8 feet tall. Um, Along the same lines, with dates, times, you might not recall exactly this is the exact date, the exact time, miles per hour, but I am entitled to a range. So if you know the month, the year, the approximate speed range, mile range, I'm entitled to those estimates. Okay?
Okay.
All right. Um, at the conclusion of this deposition, the court reporter is going to put down everything that we say into a transcript, and it's going to read much like a play. You're going to have an opportunity to review that transcript and make changes to your testimony as you see fit. The only caution that I have is if you make substantive changes, say a yes to a no, green light to a red light, 0 miles per hour to 50 miles per hour, I may be able to comment on those changes at trial or any other hearing in this matter, which might impact your credibility as a witness. Okay?
Okay.
All right. Lastly, this isn't going to be a long deposition, but if you need a break, please feel free to speak up and let me know. We can take a break at any time. The only caveat is if I have a question pending, I'll ask that you respond to the question and then we can go off the record. Okay?
Okay.
All right. Excuse me. Apologize for the frog throat and potential coughing throughout the deposition. I'm slightly under weather.
Okay.
All right. Let's see here. All right. So you understand that we're here to discuss the Chevy Silverado 1500 that you purchased. Is that correct?
Yes.
All right. And for the record, I'll state the vehicle. All right. Have you seen this document before today?
Yes.
Okay, great. And prior to your deposition, do you believe you produced all the documents relevant to the Silverado?
Yes.
We'll go ahead and mark as Exhibit 2. This is plaintiff's initial disclosures. Sorry. Apparently my computer believes it's New Year's Eve already. It's taking a second. Put it up on my screen here. Let me know when you can see it. Can you see the document?
Yes.
All right. Have you reviewed this document prior to today?
Yes.
All right. And did you help prepare this document?
Did I help prepare the document?
Yes, correct. Did you provide information to help prepare the responses in this document?
I provided information to my attorney.
All right. When did you purchase the Silverado?
Uh, I believe it was 2021.
Okay. Closer to the beginning of the year or end of the year?
Um, I don't recall if it was beginning or end of the year.
All right, we'll get there. Um, are you married?
Yes.
Do you have kids?
Yes.
How many kids?
One.
All right. How old is the kid?
She's 3.
Um, in 2021, when you were looking to purchase another vehicle, why were you in the market?
Um, my wife was pregnant with my child, and I was looking for a vehicle that would be safe and reliable for the family.
And when was your daughter born?
January.
So that would have been January of 2022.
Yes.
All right. At the time that you were looking to purchase or another vehicle in 2021, what other vehicles did you own?
I owned a Toyota Tacoma.
All right. Any other vehicles?
Um, I believe at the time my wife had a Mazda 3, I believe, is what we had back then.
Okay. I take it you don't have the Mazda 3 anymore?
No.
Does your wife have her own vehicle at this time?
Yes.
What other vehicle does she own?
Mercedes SUV.
All right. And other than the Silverado and the Mercedes SUV, do you currently own any other vehicles?
Yes.
What other vehicles do you own?
Tesla Model Y.
Any others?
No.
All right. And who's the primary driver of the Silverado?
It would be me.
All right. Has your wife ever driven the Silverado?
Yes.
How often would she drive the Silverado?
Um, Not very often. I would say maybe a couple times a month.
Okay. Um, Prior to purchasing the Silverado, did you do any online research? Go to GM's website, Chevy's website, dealership websites, did any research on vehicles that you were potentially interested in?
I mean, I did look at vehicles, yes, on GM's website. I also looked at Toyota, other. I just looked around.
Okay. And that brings me to my next question. What other models? So you were looking at the Toyota, GM products. What other manufacturers were you looking at when you were looking to purchase a vehicle in 2021?
Outside the scope. Go ahead.
Mostly Toyota and GM or Chevy.
All right. Other than the Silverado, what other GM products or models were you looking at, if any?
I looked at GMC, Chevy, trucks. Only the trucks.
Okay. What do you do for work?
I'm a correctional officer.
Let's see here. So, have you ever worked for an auto manufacturer before?
No,
Have you ever worked for an auto dealer before?
no,
Have you ever worked at an automotive mechanic shop?
no,
All right. Have you ever worked on cars personally? As either a hobby or just out of necessity or desire to change the oil filters, or upgrade vehicles, anything like that?
no,
All right. So you wouldn't consider yourself an automotive repair expert, correct?
no.
All right. As a correctional officer, do you get a vehicle from the state?
No.
Outside the scope.
Um, since you've owned the uh, Chevy Silverado, what do you primarily drive it for?
Um, just work and errands.
And do you report to an office for work?
No,
Do you work from home?
no.
All right. So as a correctional officer, do you have to drive to different locations depending on what you have to do?
No,
So where do you normally drive for work?
I drive to the state prison that I work at.
Okay. And do you go to the same state prison
Yes.
on the days that you work? Okay.
Okay.
All right. And how far is the state prison from your residence?
From my residence, it's maybe 5 minutes away, 10 minutes away.
Okay. On a monthly basis, how much would you say that you drive the Silverado?
Um, I'm not sure. Um, maybe a couple hundred miles a month.
If would drive the Silverado, what would she drive it for?
Um, the same reasons.
Okay, so she's driven the Silverado to her job?
Yes.
Hello, my name is Kelly Hyman, and I'm an attorney at Cersei, Denny, Scrolla, Barnhart, and Shipley. I'm here today to discuss with you depositions. A deposition is a pre-trial testimony that is given under oath. During the deposition, the opposing attorney will be asking you questions and you will be answering them. The court reporter will be recording the opposing attorney's questions and also your answers. The purpose of the deposition is for the opposing counsel to find out information that you know about the case. There's a saying that you cannot win your case in a deposition, but you can lose your case in a deposition. If there's something that you are worried about or concerned about that are going to be asked during your deposition, it's important to talk to your attorney before your deposition to discuss this with them so that your attorney is aware of the situation before the deposition occurs. A deposition could also be videotaped as well. So if you are videotaped, it's important to be mindful of that and that know that any kind of body movement is going to be recorded. So if you're like this and cutting yourself off, it's going to come across on the videotape. If you're rolling your eyes and doing like this or wailing your hands, that's going to come off on the video camera. So it's really important if you're videotaped to think about that and to be mindful that you're being videotaped and recorded. If an attorney knows of something ahead of time, it's much easier to handle it at the deposition when you're aware of that rather than occurring during the deposition itself. So it's important for you to let the attorney know if there's some issue or some concern that you have or something that's going to worry you about the deposition before the deposition occurs, so the attorney is aware of the situation and can plan accordingly for that issue. The number one would be to always tell the truth. No matter what, tell the truth. You're under oath and you need to tell the truth. Also, the opposing attorney will ask questions which they usually know the answer to already. So it's important for you to answer those questions honestly and truthfully. Number two would be to listen to the question. It's really important that you hear the question asked. If you don't understand the question or did not hear the question, it's okay to ask the court reporter to read back the question or ask the attorney to ask you the question again if you did not hear the question. It's important for you to ask the attorney to read back the question for you or ask the court reporter if you didn't understand the question. You shouldn't guess. If you don't know the answer to the question, I don't know is the answer. Don't ever guess a question, especially if you don't know the answer to it. It's important to remember that the opposing attorney is not your friend. They may ask questions in a very nice way and be polite, but they're not your friends. You can lose your case in a deposition. And so remember, you cannot win your case in a deposition. If you need to take a break, take one. Good luck on your deposition.
Me the questions I should ask. You will have your opportunity at the end.
Just
of
shut
my
up and move
questioning.
on with your questions, okay?
Mr. Curry.
Just shut up, or I'll adjourn this deposition, and you can tell it to the judge, or I'll get you some tissues and you can cry.
Mr. Curry.
All right?
Please don't tell me what to do.
You asked him if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him. It is a bullshit question. It is absolutely speculative, no foundation, or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
Are you
Do
aware?
you understand the question,
Are
Mr.
you aware
Schiff?
of the local rules
Mr.
with
Foster?
regard to what objections you're allowed to make and what
Do
you're
you
not?
understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of
Call the
objections you
bailiff.
can make. Objections
Call
to
the
form.
bailiff.
Sir.
Do you understand the question you're being asked, Mr.
Mr.
Foster?
Curry,
Don't ever presume that you get to tell me what to do or when to do it, counsel. Don't you ever presume.
Why
Mr.
should you
Foster,
be
this is
entitled-
your deposition. Do you understand the question?
why should you be entitled to then tell me what to do? Doesn't it go both ways?
Because I'm being straight with the guy and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about
He
the
has no
question?
dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
You don't think you're
Okay.
trying to coach the witness right now?
I'm telling him what the question is so he can answer it.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay? You got me? Do
I
we
wanna
understand
know
each other?
if you understand the
Are we
rules.
connecting here? Because
I'm
if we're not
trying to
connecting
proceed.
here, I will try again. Okay? Don't give me local rules, don't give me procedures, don't give me professionalism. Just put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think you're practicing a few
So-
years more than me, actually.
so-
That's it,
so-
to be honest with you.
Do you understand the question?
Mr. Curry,
Let's have the question read
it is
back,
my
please.
desire to follow the rules. If you don't believe we should be following the rules, then maybe you need to explain to me what procedure we are supposed to follow.
Now, do you think that there's anything wrong with adding Testmaster students who you met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
Would you read the question back, please?
Now, do you think that there's anything wrong with adding Testmaster students who met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
An object to the question is no foundation. It calls for speculation, seeks a legal conclusion, it's argumentative, and I'm instructing the witness not to answer.
Mr. Tatey, do you think that it would be improper for you to copy your employer's course material while you're a Testmasters instructor and use it for a competing business?
Same objections, same instruction.
So as we sit here today, you don't know whether or not it's a true statement that as of March 30th, 2005, Blueprint had not yet finished the writing and production of its LSAT course.
Objection, argumentative, also invades the attorney-client privilege and the work product doctrine, instructed not to answer.
Do you deny, Mr. Tatey, that as of January 12th of 2005, that Matt Riley was a Blueprint partner?
Objection, same objections, same instruction.
Mr. Curry, this goes to the very heart of the case here, and I'd ask you to reconsider your instruction and allow Mr. Tatey to answer this very simple fundamental question.
I've reconsidered. The answer is no.
Can you rule out the possibility that Matthew Riley was a Blueprint partner while he was still teaching for Testmasters?
Same objection, same instruction.
Do you deny that Matthew Riley was a Blueprint partner at the same time that he was teaching Testmasters classes?
Same objection, same instruction.
Do you deny that Matt Riley was working on the Blueprint website while he was still teaching classes for Testmasters?
Objection, it's argumentative, calls for speculation, there's no foundation, instruct the witness not to answer.
And can you say with certainty that Mr. McCarthy did not help in any way in helping Blueprint create the course material?
Objection, calls for speculation, no foundation, it's argumentative, instruct the witness not to answer.
Do you deny that Courtney Martin was working for Blueprint on its website while she was a Testmasters instructor?
Objection, same objection, same instruction.
Were you trying to get Courtney Martin to do work for Blueprint while she was a Testmasters employee?
Objection, vague and ambiguous. You can answer if you understand the question.
I don't believe that I was.
Do you deny that you were?
Objection, asked and answered. Argumentative, no foundation, calls for speculation, instruct the witness not to answer.
Now, why around this time period did you want to damage Robin Singh?
Objection, calls for speculation, no foundation, it's argumentative, instruct them not to answer as phrased. Okay, that's it.
Well,
Thank you.
let me.
No, we're done.
Okay, that's fine. I'm not asking any more questions. I want to make a record here, if I may, Mr. Curry. I think that your instructions not to answer numerous questions are improper and unfortunate, particularly in light of these new documents that were just discovered. The judges repeatedly suggested that we should, there's a likelihood of having follow-on discovery after e-discovery. I think that it's improper, and I think that you're obstructing our ability to get to the bottom of these critical and highly damaging documents. And I'd like to put you on notice that if you don't allow us to continue to ask questions now or at a subsequent time, that we believe that you will be obstructing our ability to obtain evidence about improper discovery abuses by your client, and that you will be aiding and abetting in those discovery abuses. And I ask you to reconsider and permit us to ask Mr. Tatey these questions.
Take your threats and put them where you know better.
Well, I'm not making threats.
Yes, you are. Just tell it to this. Somebody cares. See you Wednesday. Same step and my usual orders. Thank you.
Like your work, Mr. Curry?
Sure.
Like your work?
Sure.
Like your work, Mr. Curry?
From your house?
I would say approximately 25 miles, I believe, is what it is.
All right. Since you've owned the Silverado, have you taken it on any long trips, say over an hour?
Yes.
All right. Where have you gone?
Several places that I've driven it to Oregon once. Occasional trips to Nevada, Los Angeles, the
Okay.
Bay Area.
How far is Oregon from your house? I'm just curious. That's a lot. It seems like a long
It
trip.
was a very long drive. Honestly, I'm not sure. It's
Okay.
like, yeah.
And how many times have you driven to Nevada?
Several times, I guess. I'm not exactly sure the exact number, but I would say maybe 5 to 10, maybe.
Okay. What was the last long trip, road trip that you took?
I'm not exactly sure. Over an hour, probably Bakersfield.
What was the last time you drove to Nevada? I guess is what I was getting at. Sorry, I just didn't say Nevada.
I, I don't recall the last time we went. It was, I believe, sometime during the summer of this year.
Okay. All right. And when you would take these trips that you just kind of listed out for me, Oregon, Nevada, Los Angeles, would you go with your wife and daughter, or?
Yes.
All right, okay. I guess I was going to clarify. Are there any times where you would make that drive by yourself?
No.
Okay. All right. And other than your wife and you, has anybody else you know driven the vehicle?
No.
Since you've owned the Chevy Silverado, have you added any or had installed any third-party aftermarket parts, such as, say, an alarm system, video screens in the back of the headrests, anything along those lines?
No.
All right. Since you purchased the Silverado in 2021, who have you insured it through? What company?
USAA.
All right. Since you've owned the Chevy Silverado, have you been involved in any accidents as small as, say, curb rash on the tires and rims to an actual contact with another object or vehicle?
Yes.
All right. Uh, has there been one or more than one?
Just one.
Just one. Okay. And what type of accident was it? Explain what happened.
I was making a left-hand turn, and I was through the intersection, and a vehicle coming from the opposite direction, turning right, as I was passing by where they were turning right, they hit me. I believe it was in the passenger side, right behind the rear seat on the
Okay.
like bed of the truck. Or no, it was the front. It was the front.
Okay.
Yeah, they hit me like right on the passenger side in the front.
Got it. And I take it you guys exchanged insurance information. Did you report it to your insurance company, USAA?
Unfortunately, I didn't exchange insurance information. The other driver, did a hit and run. But I contacted my insurance company.
All right. Did you make a claim that they paid out on?
Yes.
And do you recall how much in damage to the vehicle there was, meaning what was provided in, say, a repair estimate?
You know,
Call for opinion. Go ahead.
I don't recall.
All right. But they provided you with like an estimate breakdown of what needed to be repaired and the estimated cost if you went through whoever they wanted you to take the vehicle to, correct?
Yes.
And when was that accident approximately?
Um, I want to say it was within the first year of owning the vehicle.
Okay. And you said you were making a left-hand turn, so I take it that was on a city street?
Yes.
And where did you have the vehicle repaired at? What was the name of the body shop?
I don't recall off the top of my head.
All right. Do you have any paperwork related to the repairs done to the Silverado uh, after it was in the accident?
No, I don't believe so.
All right. But you've always been with USAA, correct?
Yes.
And prior to producing records prior to your deposition here today, you didn't contact USAA and ask for copies of records related to that accident, correct?
No.
Okay. I'm gonna share my screen real quick. I'm not gonna mark this, but this is let me know when you can see it.
I can see it.
All right, so this is a Carfax report for the 2021 Chevy Silverado. The last four VIN is 5531. And it shows an accident reported date of 8/6/2022. Does that sound about the right time frame of when you were involved in this accident where you got hit by another car, hit and run?
Yeah, that sounds about right.
Okay. When you had your car repaired after this accident and for the damage that was caused by it, do you know how long you were without the vehicle while they were repairing the car?
No, I do not.
Mhm. Um, so other than the repair shop that fixed that did the repair work to the Silverado after the accident in August of 2022, um, have you taken it to any other third-party auto body shop or mechanic for any reason?
Not that I can recall.
All right. Um, have you ever taken the Chevy Silverado to, say, a Midas Valvoline or a similar oil service company?
No, I don't think so. I think I've always got my oil changes at Chevy.
And uh, let's go ahead and mark as Exhibit 3. This is the sales contract for the Chevy Silverado. I'll put it up on my screen. Let me know when you can see it.
Depositions. Depositions. If you've got a lawsuit, chances are you'll have to sit for one. Not to add to your stress, but your deposition can make or break your case. Don't worry. Today, I'm going to share the secrets that you can use to win your deposition. I'm also going to break down the one type of trick question that some lawyers use to trap you so you don't get it wrong. A deposition is a formal question and answer session where lawyers from both sides ask you about your case under oath. Think of it like a practice run for trial, but everything you say is on the record. Depositions are used to gather evidence, test witness credibility, and even push for a settlement before trial. The key players? You, your attorney, the opposing attorney, and a court reporter recording every word. In recent years, you're also likely to find a video camera in your face recording every twitch and every bead of sweat. Unlike in trial, where questions are asked in a specific order to tell the story to the judge or jury, your deposition questions might jump around, forwards or backwards in time, to keep you from anticipating what set of questions might be coming next. If you'll recall from our video on how to testify in court, you'll need to follow the same three-step formula. Listen to the question. Let them finish the entire question and make sure you've heard every word of the question. Understand the question. After they've finished the question, run it again in your head to make sure you are clear on what exactly is being asked of you. Don't guess what they mean. Answer the question. Don't volunteer more information than the question asks. Answer just the question being asked. Make sure that you actually answer the question being asked and don't try to dance around it. Don't waste your brain power trying to find a way to outsmart the attorney or to try to get cute. It doesn't look good in court and just drags the process out. If the answer is yes, then say yes. If the answer is no, then say no. If it's not exactly yes or no, then don't admit or deny something that isn't exactly true. I guarantee that you're going to be asked a question that you don't know the answer to. It might be something that you never knew, or it might be something that you just can't remember. There is a difference between not knowing something that you never knew and not being able to recall something that you once knew. If you can't recall something that you once knew, then don't say, I don't know. Instead, say, I can't seem to recall right now. This leaves open the possibility that you might be able to recall it in the future. Once you recall the answer to a question, though, you need to make sure that you inform the other side and don't just hold it until trial. That's a fast way to get your evidence excluded. In depositions, specifically here in Texas, there are very limited objections available to the attorneys. There are just two that you need to be aware of: objection non-responsive and objection form. Objection non-responsive is what you should expect to hear from the attorney asking you questions if you start volunteering extraneous information or if you don't actually answer the question being asked. If you hear that objection, then you should expect that they will then ask you the same question again, so pay a little closer attention and remember step 3 to testify. Objection form is what you will likely hear from your own attorney who believes that the form of the question being asked is not permissible. The question might ask you to speculate, be a vague question, or it might be a compound question, meaning there's more than one question in that one question. If you hear your attorney assert objection form, just know it's like a bookmark for all of the possible objections that the judge will rule on later. You'll still answer the question to the best of your ability and to the best of your ability to understand what's being asked. In rare, very limited circumstances, your attorney may instruct you not to answer a question. This is where step 2 to testifying is so important, because that moment that you take to consider and understand the question being asked gives your attorney the opportunity to interject and instruct you not to answer. You'll only be instructed not to answer a question for things like abusive questions, preservation of privilege, or to comply with a court order. If your attorney instructs you not to answer, but you've already blurted out the answer, or you continue answering despite this instruction, then what are you even paying them for? While you're testifying, don't expect any help from your attorney. That's the reason that they have very few objections available, so that way you aren't tipped off on how to answer. One thing I've seen happen a few times is the witness asked their attorney how to answer a question, the answer of which wouldn't paint them in a very positive light. I had to remind the attorney not to assist, which of course made the witness mad and affected how they looked on camera. Some sneaky attorneys like to ask you whether you've ceased committing certain actions that you've denied ever doing. This is sneaky because there is no right answer. Here are some classic examples. Did you quit using drugs? When did you stop embezzling money? Have you stopped beating your wife? If you say yes, then you're suggesting that you had previously done this act and have now stopped. If you say no, then you're suggesting that you're still doing this conduct. If your attorney is paying attention, then they should instruct you not to answer such a question. If they don't instruct you not to answer that question, then you should refuse to answer. Your deposition might not be video recorded and might just be recorded by a court reporter with a stenograph machine. If that's the case, then definitely make sure that you are speaking slowly and clearly enough for them to accurately type down your answers. This is important since the judge will not be able to listen to your actual response in context if there's a disagreement over what your answer was. If your deposition is video recorded, then that recording can be played in front of the judge or jury at your final hearing. This is important for you to know because you want to dress for your deposition in the same way that you intend to dress for court. Don't show up to your deposition in a baseball cap, wearing a vulgar t-shirt, or looking generally unkempt. In fact, you should take a minute to review some of our other body language tips, as these are just as important in depositions as they are in court.
I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff will...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
I prepared my remarks and my decision here today, and I am, I am glad I had the opportunity to spend the night to do some deliberation on this matter and think about it.
I'll put it up on my screen. Let me know when you can see it.
I'm sorry, Counsel. What is Exhibit 2?
Exhibit 2 was the initial disclosures. All right. Can you see my screen?
Yes.
Perfect. All right. So if we look here in the upper left-hand corner under buyer's name, it lists Matthew W. Scotch, 662 Robledo Drive, Soledad, California, 93960. That's you at your residence, correct?
Yes.
All right. And it looks like the seller is listed as My Chevrolet Inc., which is likely uh, just a corporate name. Do you recall what the name of the dealership was you purchased the Silverado from?
It's My Chevrolet.
Okay, just without the Inc.
Yes.
All right. And it looks like when you purchased the Chevy Silverado, you purchased it new with approximately 40 miles on it. Does that sound about right?
It sounds about right.
Let's scroll down here.
At the time, I believe it was like a chip shortage or something, so there wasn't very many vehicles available.
Oh. All right, so on June 29th, 2021, when you went into My Chevrolet, at that time, had you already picked out the vehicle you wanted to purchase, or did they just happen to have one that you liked and were like, that's the one I want to buy?
They just happened to have one that I liked, and I was gonna, yeah.
All right. And did you take the Silverado for a test drive on June 29th, before you purchased it?
Yeah, I believe I did.
Okay. And do you recall how long the test drive was?
Maybe 5-10 minutes. I'm not super long.
Yeah. Okay. Do you recall if you got on a highway or just stayed on city streets?
That I do not recall.
Yeah. All right. So you drive to My Chevrolet, you park your car, get out. Were you initially immediately greeted by a salesperson, or did you get out and kind of walk around first by yourself?
I believe I walked around for a second before a salesperson saw me.
All right. And had you seen the vehicle you ended up purchasing before a salesperson actually greeted you?
I don't recall. No, I don't recall.
When you test drove the vehicle, do you recall any issues with the Silverado at that time?
No.
All right. So after taking it for a test drive, I imagine you went back inside and started talking numbers, and either negotiated the sales price or they told you this is what it is, and the cash price that was listed is $57,525 here on page 2 of the sales contract. Is that about right?
Yeah, that sounds right.
All right. And then it doesn't look like you purchased any additional service contracts or warranties, correct?
No.
Okay. But you did trade in your 2015 Toyota Tacoma at that time, correct?
Yes.
All right. And the net trade-in value for the Tacoma that they gave you was $13,000?
Yes.
Oh. And then if we look over here on the left-hand side, it looks like you received a $5,000 rebate from the manufacturer, from General Motors.
Yeah, I believe so, yeah.
Okay. And then just below that, it looks like you put down an additional $2,000. Does that sound about right?
I believe it was $20,000.
20? I'm sorry. Yes, it does look like there should be a comma there. Yeah. $20,000, correct?
Yes.
All right. My apologies. And so after the purchase price, taxes, title, registration, and other processing fees, and your down payment, it looks like you financed $25,639.68. Does that sound about right?
It sounds about right.
All right. Did you end up financing the Silverado through GM financing?
I believe so, but then I think how it worked is I financed it through GM and then went through refinanced it through my bank.
Okay, and who's your bank?
Coastal Federal Credit Union.
Okay. And so at the time that you purchased the Silverado, it looks like your payment was approximately $399.32. Does that sound about right?
Yes.
What's your payment on the Silverado now through Coast Health?
I believe it's around the same price, maybe a little bit less.
Okay. You got a pretty decent interest rate there at 3.79. I take it Coast Health gave you a little bit better deal?
Yeah, I can't remember I don't remember what the percentage rate was. It was more a convenience thing.
Got it.
Your Honor, may we excuse the witness? Your Honor, may we excuse the witness?
Yeah, Mr. Smirker, you can go ahead and step outside for us. Thank you.
Your Honor, so well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up?
Yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah,
okay.
The comments generally being all of the writing on the right side of the picture.
Your Honor.
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And asking
no,
him
Your Honor.
to testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this social media page.
You represented at the bench that none of this that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked
at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I mean, I can't figure out what it is. If